Just one. Huh?
Can law involve this litigation?
We have already gone to the process.
Lordship.
We have gone to it.
Lordship.
There has been a divergence which has been done.
Lordship.
We need to be a community of aboriginals who
Lordship.
are saying that you are there, you are being affidavit.
Lordship.
We have seen their counter affidavit as well.
Lordship, one point I have to.
There are two intervening applications.
Lordship. Lordship,
one
pertinent fact, Lordship, I'm to bring to Lordship's notice. It's a Gram Panchayat area admitted because they have called the Gram Sabha, and it is for not for the diversion only, for the sake of diversion of the forest land as well as.
Sir, we have seen that you say that they are eating up some of the lands of the Adivasis. They have taken a very specific stand in the counter affidavit as well.
Lordship, that is that the resolution of Gram Panchayat, Lordship, it is written in Odia. One part it has been suppressed last date, that it is also for the sake of regarding the realignment.
That is what is there.
So that it is a Gram Panchayat area admitted. So one urban road transgressing, foraying into a Gram Panchayat area, creating administrative.
Permissible according to any road which encompasses the Gram Panchayat area is impermissible.
Lordship.
Very good stand. We'll consider it.
Lordship, that Lordship, our only prayer is let it's a consultative process should be called for. Let the objections be invited. Let there is a process of consultation with the affected parties, and thereafter the road. I'm not standing on the way of construction of a road. I'm also conscious.
Item number 2.
Supplementary to start ହେଲା ଦେଖୁଛୁ supplementary to 1466 हम କୋଉଠି ଥିଲେ ଆମେ weekly 2 ଅଛନ୍ତି ଆगे weekly 1 start ହେଲା ତାପରେ supply 2 ପଳେଇଲା
FPCL matter, IOCL matter, your lordship have been pleased to deliver judgment. NOC which was cancelled by IOCL has been set aside by your lordship. On the at the stage of so cause, consequence of cancellation, the so cause was issued.
This counter has come.
Yes, my lord.
Counter has come, but I have seen the counter. There is subject to if your lordship permits me to look into it, but there is little amount. They have said that they have issued LOI in favor of some other persons, and they are taking a stand that those LOAs holders are necessary party. In my opinion, they are not necessary.
That I leave it to their. It is my submission.
There are two judges, the court is saying not necessary.
Not necessary because LOA is provisional. Consequent upon, Lord, I have an interim prayer here.
Well,
Lord, on beg pardon, Lord.
do you want on Monday,
Monday, Lord.
keep it on Monday,
Oblige, my lord.
Monday? Go through the.
I'll go through it. Lord.
If you want to intend, use the.
Only my
rejoinder.
Right. I
Use
can-
the rejoinder, give it,
Right.
on Sunday.
Lord, I'll only pray, Lord. My humble prayer is, Lord,
Monday, today is a Friday, that's the first available day. Because you just do it,
let
prepare
them
it
not,
today itself. If necessary, give him at least 1 day before.
Lord, let them not take any further action.
I understand. Then let it come on Monday, that's why we keep this on. Let the counter affidavit filed by the this is an application.
And next list.
No, you have gone back?
Oh, my God. Sorry, one second.
Yes.
Weekly list, item number 1, WPC 27440 of 2025.
Immediately, Lordship. Here the petition challenged the illegal seizure of 2 excavators, Lordship, by the mining department in contrary to the rules, and Lordship, acknowledge Lordship judgment, Lordship, the recent judgment has come out considering the same issues, Lordship. But here, Lordship, before going to the Lordship, other points, Lordship, I want to bring Lordship's kind notice the facts of this case, Lordship. Very precisely, Lordship, I will, Lordship. Lordship, straight away, Lordship, kindly come to Lordship, Annexure 1. The petitioner is a lessee for a particular source, Lordship, for 5 years. It starts from 2022, Lordship, and still it is operating, Lordship. And Annexure 1 is my, Lordship, lease deed with the opposite parties. And so, while this was the position, Lordship, kindly state, Lordship, come to Annexure 3, page 56, Lordship. They made a surprise visit by constituted committee. Lordship, it appears at turning page 56, Annexure 3. They issued me show cause on 2/6/2025, stating therein seizure of my vehicle, Lordship. Here I am confined to my seizure of vehicle, Lordship. I am not raising any the other issues, Lordship. Lordship, may I read, Lordship, show cause note?
I have already read.
Lordship. Then, Lordship, they are on presumption.
You have also constructed a road across the
That is there, Lordship. I don't dispute. That is there. I am not on that. I am on issue, Lordship. I am restricting myself, Lordship, on the seizure of the vehicles. If I convince the Lordship it is illegal, then Lordship grant me some relief. If it is, Lordship, they will.
If it is illegal, then grant you a relief.
Lordship. Illegal seizure, Lordship. Illegal seizure, I am saying, Lordship, not a. Lordship, illegal seizure. Lordship, the language, Lordship, what they have employed, Lordship, kindly see. With reference to subject, I am to say that during the field visit of GB Nagar area, in and around village Khontapal, by mining squad on 35 and 25.
It is outside the purview of the lease
Lordship.
and you have also constructed a road
No, Lordship.
to the river
I'll come to that, Lordship.
that obstructed the natural.
Lordship, I will explain every Lordship allegations, but Lordship, I am before Lordship explaining all the allegations.
You've given a reply to this.
Yes, Lordship, may read, Lordship. That allegations, Lordship, permit to read, Lordship. Symptoms of mechanized, Lordship, and presumption. They are not saying allegation of
mining.
Lordship. Symptoms of mechanized mining was detected outside the lease area, not inside lease area, Lordship. The Gitu bed, and you also construct a road across the river from opposite side to the source, obstruct natural flow of river. Further, the squad has seized 2 numbers of excavators, Lordship. Here is a past, Lordship. They have seized without any allegations to against this machinery, Lordship, and detect approximately 30 cubic sand stacked illegally outside the lease area. So the allegations, Lordship, here they are saying some deviation in mining, Lordship, stipulations on mining plan, that they are saying you have constructed a road by obstructing natural flow of the water, and Lordship, they are saying 2 excavators we have seized, anticipating or presuming that may have been used in that illegal mining, Lordship, and they have pointed out stacking of 30 cubic sand. That is their entire allegation.
These 2 things were found outside the lease.
That's true, Lordship.
Then
that's true, Lordship. I'll explain, Lordship. I'm not on that, Lordship. I'll explain.
What is the reply? Tell us.
Lordship, Lordship, kindly come to Annexure 5. Page 61. This was my reply, Lordship.
Correct.
Lordship, the temporary road across the river, Lordship, I'm reading one by one. The temporary road across the river was constructed solely due to persistent disturbances by the local villagers.
Page 61.
Lordship, page 61, Lordship, Annexure 5, that is 5/6/2025. Within the.
No, I have not. What you are reading, I am not able to.
I am reading, Lordship, first paragraph.
What bullet point?
Bullet point 1, Lordship. 1, Lordship.
Was constructed solely due to persistent disturbances of the local villages on primary access route to the leased area.
Lordship,
This disruption prevented the lawful operation of the sand court and compelling us to create an alternative path to resume the essential activity.
Lordship.
That is what you say.
No, I'm on to bullet point 2, Lordship, because
Two.
this read
Upon
person
receiving
confined to
the
Chidara
notice, they
only
halted all the
excavators.
operations.
Lordship,
Immediately after receiving the notice, you halted all the operations, acknowledge the concern regarding obstruction of the such and such, and assure you that no further activities will occur on this route. The excavators detected were not engaged in a mechanized mining outside
Lordship,
the lease area, but were stationed temporarily due to this. So
Lordship.
you have also admitted it was found
It is
outside
found,
the lease.
yes, in the village, Lordship. In the village, these two excavators were, Lordship,
Village is
in-
something anyhow. That is a gray area anyhow.
Lordship. But
Yeah.
admittedly, that is also their
They
case.
have not said so anyhow.
Lordship, this is admitted case of both the parties, Lordship. These two vehicles were.
Now that is what we wanted. What is the law?
I'm coming to that.
So straight away,
The Lordship.
the allegations have been admitted. You have given some explanation for that. Let us see what.
No,
is the-
not allegation. So far, the construction of road has been admitted.
No, sir. There were three allegations.
Lordship,
One is there is a symptom of a mechanized.
grateful Lordship, Lordship,
mining.
Lordship,
Second thing is the construction of a road
Lordship,
beyond the leased area.
Lordship,
The third one was keeping of two excavators outside the lease area.
grateful Lordship,
These are the three grounds
Lordship.
against whom
Lordship,
you admitted all three.
Lordship.
You say yes, I have
Grateful, Lord.
constructed a road,
Yes,
but
Lordship,
there was a lot of protest given by the villagers. I
Lordship,
was not getting an access. I
Lordship,
temporarily constructed the road
grateful Lordship,
for ingress and egress to my leased area.
Lordship,
So that is an admission position. You constructed the.
Lordship. That is the
The
answer.
second thing is you say yes, it was kept just outside the area. It's not does not mean that I have been doing anything. So this is also admitted that the excavators were kept outside the area.
Grateful Lordship,
The third allegation is that there is a symptom of a mechanized.
Lordship,
Once the excavators have been put into use, so that presumption can be raised,
Lordship.
and the confiscation they have done. So these four aspects which they have highlighted, admitted by you. Now show us the law.
Grateful
What
Lordship.
is it?
Then Lordship, kindly come to Annex 7. What they
Yes,
did,
please.
Lordship. In considering my Lordship explanation, Lordship, they passed order on 24 Annex 7, Lordship, 24/6/2025.
Yes.
Page 64, Lordship. Sorry,
Yes.
Lordship. May I read, Lordship?
No, I'm a very fast reader than you.
So that's why, Lordship, I'm seeking permission, Lordship.
So they have said that you have that I do not admit any of your explanation to be
Yes.
satisfactory, since you have deviated from or a violation of the conditions enshrined in the mining plan.
Lordship,
So you are liable to pay.
Lordship.
That is
What
what
they
is
did,
simple.
Lordship, kindly come to Roman 1.
Yes. For violation of mining plan, 50,000 as per Rule 3317 Amendment Act of 2016, and illegal stacking is 30 cubic meter of the sand they have imposed.
Lordship, I will go one by one, Lordship. Lordship, kindly come to 33/7.
Royalty 24,000.
Lordship,
Then the DMF 315. Compensation 6,593.
Lordship.
Total 31,000. Engaging Mr. Duloi to argue.
Lordship, then kindly come to next page. 30 to page 65 also there, Lordship. There's some operative part, Lordship, there.
Yes.
Further, you are hereby directed to submit copy of tax invoice (bills) of the seized two numbers of chain-mounted excavators, Volvo and Tata Hitachi, immediately
Which one you are?
Lordship, next page, just next page. Well, there is a concluding part. 65, Lordship. This small paragraph, Lordship. You can.
Correct. So they have said that I am keeping it. You deposit. Your
Lordship.
challan will
Grateful, Lordship.
release.
Grateful, Lordship.
Noted.
Lordship, then I will go one by one, Lordship. Lordship, kindly come to Roman 1. Roman 1, they are saying they have
You
imposed.
have not replied to my observation. First observation.
Lordship, sorry, Lordship. Point. I'm showing the point, Lordship.
First observation.
Lordship, but Lordship, I will come. Lordship, why have Roman 1, Lordship.
What Roman 1?
Roman 1, they're saying in violation of 3317 of the rules, Lordship, they've imposed me cost of rupees 50,000. Lordship, kindly
It is I think the
Penalty.
penalty. Lordship, kindly come to 3317 for a moment. I'll go one by one, Lordship. 3317 for a moment.
This is
Odisha minor mineral constitute
rules, you have said amendment rules.
because of 2023 they've come up with amendment, Lordship. That's why in it is 2014, Lordship.
It has been incorporated
Lordship.
in this.
This
book.
Lordship. Rule 17.
Yes, sir.
37. May I read, Lordship? If the lessee does
Does
not
allow the
allow
inspecting
Lordship
inspector
reasonable facilities for inspection of or fails comply with the directions within the specified time limit, the competent authority may forfeit the whole part of the secure deposit paid by the lessee or impose penalty not exceeding rupees 50,000 and may cancel the list.
So, according to you, these incidences are not there.
Grateful, Lordship. So, Lordship,
Pay 31,000.
Lordship 31. Lordship.
Pay 31,000.
Oh, 31. Lordship. Then I'll come to 31,000. I'll explain, Lordship. But, Lordship, for illegal staking of 30 cubic sand outside area, and they impose the royalty, Lordship. Then, Lordship, if you we should read the conjunctive, Lordship.
They will give you 2 excavators.
Lordship, 31,000 is not permissible. I will give Lordship. 31,000, there is no objection. But Lordship, there is serious allegations, Lordship. What they did, Lordship, kindly see. If they will flout these provisions like this, Lordship, no one can survive, Lordship. It is due to personal vendetta, Lordship. Because we are not meeting their illegal demand, these are coming up, Lordship. Lordship, kindly allow me only 10 minutes, Lordship. Another 10 minutes I can.
No 10. So it is not confined to the execution of that particular power attorney or the authorization letter uh, as ordained in Appendix 2 or to the documents. What is the Appendix?
Appendix 2, Your Lordship, may kindly turn to page 81 minutes. 81, my lord, is the format for power of attorney to be signed by the bidder.
So, no difficulty.
Then Your Lordship would see the signature, name, signature, designation, and address of the person authorized by the board in case of firms, companies, partner, in case of so and so. And if Your Lordship would turn over the page, the notes, Your Lordships were referring to note 2, unnumbered note 2. Wherever required, the bidder should submit for verification the extract of the charter documents and documents such as a board or shareholders resolution, power of attorney in favor of the person.
Correct. So
My lord.
whenever required.
Whenever
it is
required.
required. It
My
is
lord.
not mandatory that you should.
Correct.
They may ask for production.
My lord.
That is what we also perceived
My
and
lord.
proceeded to grant the interim order.
My lord. And if your lordship would
Now, where
kindly-
is the rejection?
Rejection, my lord, is annex of page 157.
Page?
Page 157, my lord, annex of 4. The bid was rejected on 8/8/2025. Your lordships are at page 157.
Not attached.
Yes, my lords.
Yes,
Extract of the
extract
board
of
resolution.
The board resolution.
Not attached. So this is a singular reason for which my bid.
That is
My
we will
lord.
confine to it.
Come on,
We will not
come on.
go beyond that.
True, my lord. And if your lordship, before I take your lordship, your lordship have already seen your lordship's order. Your lordship may kindly come to the some clauses, my lord, of the my lord's request for proposal, my lords.
Clause of rejection.
Clauses of the request for proposal, my lords. Which what
Oh, clause relating to rejection.
rejection, my lords.
Show us.
If your lordship would kindly first come to page 33. Clause 2.1.5.
Yes, submission.
Submission of the thing.
That's
Then
no,
your lordship
that-
may kindly come to page 47. I'll only take your lordship to the relevant portions, my lords.
No, I do not want
My lords.
the entire
My-
one to
my
be gone into. Just relevant.
My lords. Page 40.
Powers, the source of powers, and
My
the
lords.
mandatory
My
nature
lords.
of
And the requirement of the particular request for proposal.
whatever.
Page 47, if your lordship would kindly turn.
Yes,
Clause 2.11.1, my lords.
yes.
2.11 begins with saying documents comprising technical and financial bills.
Whatever. Yes.
Then your lordship may kindly permit me to place this. 2.11.1. The bidder shall first upload all the project details,
Then
including
got the turnover details, all
Balance,
the
balance.
documents required in our RFP
Then your lordship may
for
come.
technical qualification.
Balance. Then your lordship may see the bidder shall then apply for the RFP on the
In
website
essence, submitting the
documents mentioned
along with
below.
the supporting document which shall comprise.
My lords, which shall comprise the technical bids. Now
Yes.
I'll just stop here for a moment with supporting documents. Your
That's
lordship may
true.
kindly mark that.
It's true.
This particular, in my humble submission, my lord, so far as small a is concerned, it is confined to Appendix A 1A, including Appendix 1 to small Roman 7, and supporting certificates and documents. Except this particular clause, because in the counter of the railways, they harp on the supporting documents.
Where is the provision for rejection?
Provision for rejection, my lords, 2.16. That's at page 50, my lords.
50.
50. Rejection of bids. 2.16.1. Notwithstanding anything contained in this RFP, the authority reserves the right to reject any bid and to annul the bidding process and reject all bids at any time without any liability or any obligation for such acceptance, rejection, or annulment, and without assigning
It's the unbundled power that cannot be done.
Balance.
Then
And if your lordship would kindly turn to Lord page 47, come back again to page 47B. It talks about the power of attorney. The power of attorney for
yes,
signing
I've
the
seen,
bid.
as per the format
What
of
Appendix 2. And your lordships have already seen Annexure 2 and the note therein which says wherever.
And that's true.
Months. Then your lordship may kindly turn, my lords, to 47 2.11.1. And if your lordship have already seen, then your lordship may kindly come to page 47 at page 47, clause 2.11.2. The Manoj. The bidder shall submit the following documents physically within the time as mentioned in clause 1.3.
Yes.
A. Original power of attorney for signing the bid as per format in Appendix 2.
And B, if applicable,
Original power, that is not applicable to us.
Appendix 3, that is not.
That's not applicable to me because I'm neither a consortium nor a joint venture.
Clause 1.3.
Clause 1.3, if your lordship would come back, my lords.
Schedule of the bidding process is the 1.3.
My lords.
Oh, this is that.
That's page 31, my lords.
Yes, I got it.
That's a schedule, my lords.
Yes, that's understood. That's the schedule.
My lords. And admittedly, my lords, the petitioner was in possession.
You have given an appendix 2, notarized by a person.
My lords.
And thereafter, you were having or in possession of the physical documents.
My lords.
And you were under the impression that as
and when it required,
you will give.
True, my lords. And if your lordship would kindly come to the board's resolution at page 150, it is already there. 129, before your lordship comes to my lords, page 150. Your Lordship may kindly see page 129. The power of attorney and the Lordship got it?
Yes, I got it.
This one Santosh Kumar Jha, Chairman and Managing Director, Konkan Railways, having so and so, authorized Sri Upendra Sridhar Shinde, at present residing so and so, position of Chief Project Manager so, to sign. And accordingly, page 131, if your Lordship would kindly turn to it, page 131, at the left-hand side, Santosh Kumar Jha, Chairman, Managing Director, Konkan Railways. Then it is accepted by Upendra Sridhar Shinde, who is the person who has submitted the bid. Now, so far as my board resolution is concerned, my lords, it's Annex 3 at page 150, my lords.
No, that is what is general power attorney. 150 is a general extract of
Extract of the 16th meeting,
I know.
which, my lords,
That is
which,
under the Companies Act. It is
my
required.
lords, my lords. And if your lordship would appreciate one more submission which may crop up in your lordship mind, that there is always a clause also to subdelegate. Because Santosh Shinde was subdelegated by Jha. And that particular clause, my lord, is at page 155. That is paragraph 13, 31. Second subpara, then 1, 2, 3, last 3 lines, if you could see. Further,
the board of directors authorize managing their subdelegate any of the
My
powers interested in this.
So, my lords, there is a power to subdelegate. I was authorized, Jha, Mr. Jha was the authorized person by virtue of the board's resolution. Mr. Jha was given the power to subdelegate, and Mr. Shinde, my lord, was the person, the delegatee of Mr. Jha, who had given the bid, my lords. And, my lords, I had the board's resolution with me, authorizing these persons. The power of attorney was very much there as a tender document. Now, the question arises, my lord, whether this particular document as the board's resolution could have accompanied the tender and whether it is an essential condition of the tender document. Now, that is a simple aspect. Now, they have filed, my lords, a counter affidavit so far as the railways are concerned. I'll just take your lordships to, that is that, my lords, flag B, counter affidavit filed, my lords. I'll take a lordship to certain paragraphs of the counter, my lords. Your lordship got it now? Paragraph B. Paragraph 5, my lord. 7. I'm sorry, my lord. Paragraph 7. At page 3, internal page 3 of the counter. Lordship got it? That furthermore, the notes appended to the Appendix 2 format stipulate that wherever required, they also say.
That is what they have reflected.
My lords, the bidder should submit the verification, the extract of the charter documents, the documents such as board so and so, they've extracted.
You have not submitted the board resolution.
My lords, therefore, then your lordship may kindly turn over the page. Therefore, as in the present
No, I
case,
have already read.
my lords, then your lordship may kindly turn to page paragraph 8. Essentially, what they wanted to say in the counter, my lords, that in the present case, the petitioner has failed to submit any supporting document. Your lordship may kindly mark this word. But paragraph 8 at page 4.
Paragraph 8.
Paragraph 8 of the counter affidavit at page 4.
He has failed to submit the supporting document.
Supporting documents evidencing that the executants of the power of attorney submitted under Appendix 2 were duly authorized by a valid board resolution.
So they are taken this as a factor.
As a supporting.
As a factual defect.
As a balance. And, my lords, if lordship would again come back, my lords, about the supporting documents, my humble submission, my lord, that as per, my lord, clause 2.11, my lords,
within that,
my lords. So far as power of attorney is concerned, my humble submission would be that these supporting documents were only restricted, my lords, to paragraph 2A, my lords, if your lordship would kindly see. Page 47, if your lordship may kindly come back to page 47, my lords. The second subparagraph of clause 2.11.1. The bidder shall then apply, your lordship got it?
Yes.
With supporting documents. Your lordship may kindly mark this word. And an A, that's Appendix 1A, including annexes 1 to 7, and supporting certificates and documents. Except this, B, if your lordship see, it is conspicuously absent. So, my lords, wherever they wanted a supporting document, and if your lordship would, for a moment, at this juncture, kindly turn to page 65. That is Appendix 1A at page 65, if your lordship would see.
So I understand
My lord.
that it is in relation to an appendix 2,
My lord.
not in relation to an appendix
True, my lord.
1.
And wherever
it is supporting document is relatable to appendix A,
my lords,
and though they have said that the supporting document mentioned below, the power of attorney is in appendix 2. Note says that as and when required, you'll have to submit.
true, my lords. And wherever they needed, my lord, it was specifically mentioned, my lord, in Appendix 1A and also in Annexes 1 to 7, stipulating the supporting documents which were required. And this, my lord, is absent so far as the power of attorney clause is concerned.
It's not an essential condition.
It's not a constitutional condition.
So as to warrant
True, my lord.
your bid to be.
But unfortunately, the railways at paragraph 8, they say that this is a supporting document which ought to have been filed, and having not filed it, you are liable for rejection of your bid. And your lordship, that is point number 1, essentially what they want to say at paragraph 8. Then if your lordship would kindly turn to paragraph 18, my lords, at page 7 of the counter. So they talk about an alternate dispute resolution mechanism, which they say paragraph 18, 1.8, at page 7, my lords. So they speak of an alternate dispute resolution mechanism where they say that you should not have come to the court, but you should have opted for that alternate dispute resolution mechanism, my lords. I'll just place it and I'll make my submissions, my lord. That in reply to paragraph 7.8 of the petition, it is to be noted that the technical bid of the tender has been finalized as per condition so and so, as per clause number so and so, and there is no.
They're talking alternative forum which is
My lord,
provided.
You can't come to the court. My first humble submission would be that this cannot act as a fetter for your lordship's power of review and to strike down at injustice, unfairness in the entire process of rejection of my bid. Number 2, my lords, except for this petitioner, the other two are joint ventures. So I can't be, my lords, subjected to 2 conditions. That if I have a complaint, I go to the ADR mechanism. The other 2 persons, they are not to go. If at all there was a rejection, assuming for the sake of argument that there was a rejection. And if your lordship would see, my lord, they have annexed that as Annexure B by 1. The alternate dispute resolution mechanism, my lord. And if your lordship would kindly turn, my lord, to page 49. Before I come to page 46, I'll take your lordship because this is the basis on which they have now formulated this, my lord, this particular resolution. At page 49. Lordship got it, my lord? Page 49, my lord, of that counter affidavit.
Not 49.
That is
a letter.
That's the letter dated 28th of February
2020.
My lords. I'll straight away take your lordship. I'll not bother your lordship with the paragraph 1. Paragraph 2, my lords. It has been the constant, lordship, what is paragraph 2, my lords. It has been the constant effort of this department to reduce government litigation in the courts so that valuable court time is spent in resolving other pending cases. It has also been endeavored by the government and to see the disputes between various ministries, departments, CPSCs, board, authorities under the administrative control.
Includes the railway.
My lords, my lords. It excludes railways, income tax, customs, and excise department. Your lordship have got, and basing on this, my lord, they adopt this resolution or at page 46, which they want to rely. And if your lordship would see that it is, they have made it only applicable. If your lordship kindly turn to page 46, they apply this letter of 28. They adopt this letter of 28th of February 2020. Your lordship would get it at the 3rd line of paragraph 2. And at paragraph 3, they make it applicable to disputes other than those of taxation between central government ministries, departments inter se, and between central government ministries, departments, and other ministries, departments, organizations, subordinate offices, autonomous and statutory bodies, etc., under their administrative
So
supervision
this
and control.
This is really an interdepartmental dispute.
True, my lord. It has nothing to do with, my lord, the central,
with the private individual.
my lord, and my lord, with a person who is, my lord, a central government undertaking, my lord. This central government undertaking is not directly covered, my lords, by letter of 28th of February 2020, and this particular letter excludes railways. And there was a subsequent, my lord, authorization, if I may disturb your lordship, to take my rejoinder, my lords. So far as these undertakings are concerned, the Department of Public Enterprises, they have come up in 2022, my lords. If your lordship to take my rejoinder at flag C, because I need not bother your lordship, my lord, to again and again, my lords. Flag C at page 19. Your lordship got it? That's my rejoinder.
Circular.
Office memorandum.
Sir.
My lord. This is dated 14th of December 2022 by the Department of Public Enterprises. There, your lordship is
15.
Sorry, my lord.
15th December.
Page 20, my lord. Page 20.
Say that you were saying 19.
19.
So
No, I'm sorry. I stand corrected.
Office number.
Office. Then your lordship may straight away come to, my lord, page 21. Paragraph 3.3. Any dispute, lordship got it? Any dispute or difference,
central public sector,
my lords,
enterprises
to which the petitioner belongs. And this also excludes disputes relating to railways, income tax, customs and excise department, shall be taken up by either party for its resolution through AMRCD only. So in my humble contention, my lords, that this particular memorandum, which they want, my lord, to rely upon to say that I had an alternate dispute resolution mechanism, cannot stand to reason, because they cannot oust your lordship's review from jurisdiction, my lords. Number two, my lords, even going by the various memorandum itself, my lord, it excludes railways. Then, my lords, if I may proceed with, and if your lordship permit me, if I proceed further, my lord, so far as I'll just show only one more paragraph. That's paragraph 24 at page 11. They speak about a revenue loss and of their counter, my lords. I'll go back to your lordship. Paragraph 24, my lords. Page 11, my lords. I'm sorry. Huh? I'm sorry, no, page 11, paragraph 28. No, I stand corrected. Page 28. Page 11, paragraph
9H.
Sorry, no?
In reply to para 9H.
In reply to paragraph 9H, it is worth noting that any delay in developing the project infrastructure would result in untimely maintenance of the Vande Bharat coaches.
They're saying
there's a revenue loss. And my humble contention, my lord, is so far as L1 is concerned, if your lordship would kindly turn to the bid documents, my lord, that was opened, my lord, the price bid was opened on the same day of 8th, my lord, and the price bid, my lord, is 158.
You have quoted less.
I have quoted 45 crores less. 42. Sorry, 42.
Crores less.
Yes, ma'am. Your lordship may kindly turn to page 158 at Annexure 5. Your lordship would kindly...
Of the writ or
the writ? Of the writ petition.
150?
158 Annexure 5 notes. At the right-hand column, your lordship would get it. This is a L1's price, my lord. Lordship got it now?
Yes.
This is 28.69 less. This D has quoted a price of 375 crores, some odd crores, my lord. So far as the L2 is concerned, the gentleman opposite part number 5, he, my lord, quotes a price of 388 some odd crores.
Where do I get?
My lord, in the chart, my lord,
Yes.
L1 and L2, they make a comparison.
Correct.
So at the top, your lordship will get
Yes,
it. My lord. Then if your lordship would just...
above.
True, my lord. And if your lordship would kindly turn over the page, in my representation to them, Annexure 6, I have, my lord, at page 160. Annexure 6 at page 159. It begins at page 159. Yes. And if your lordship would turn over to page 160.
333.15.
My lords. So that is 42 crores less, because the estimated cost of the work was 291 crores. I have quoted, my lord, 333, my lords, which is some odd, which is 42 crores less. I, being a government of India enterprise, having the expertise, my lord, to complete the work, having quoted a price, my lord, of 42 crores less, it will be in the interest of revenue. They can't say there's a loss of revenue because of the pendency of the writ petition. It will be rather in the interest of the revenue, my lords. And this specious grounds rejection of my bid, my lord, and not having allowed a particular government of India enterprise, my lord, to proceed with the work is, my lord, a serious prejudice caused to the railways also, my lord, to me as well as to the railways. Because this pecuniary loss, my lord.
Yes.
And this will, my lord, cause us a pecuniary loss to them. Lord, just to sum up, my lords, I have a Supreme Court order, my lords, which says that what are the essential documents and what will be the effect. That if these documents, if they are essential or if they are supporting documents, have to be specifically, my lord, mentioned. Because one cannot hold a crystal ball to anticipate what they had in mind to bring it into the terminology of a supporting document. So, Lordship may kindly peruse, my lord. The first judgment, my lord, it's a judgment of, my lords, 25, my lords. This, my lord, was relating to a coal auction where the Madhya Pradesh High Court, my lord, had, my lord, dismissed the matter. And, my lord, it went up to the Honorable Supreme Court. I'll just take your lordship to para 3, my lords. As, lordship, as NN Global Mercantile Private Limited could not furnish earnest money deposit, only the appellant and the second respondent remained in the fray. Not the second page, page 2. 2 of this Maha Mineral, my lords.
Yes.
Page bottom is at the.
No, that's why I asked you.
I'm sorry. I'm
looking at it.
I'm sorry. Paragraph 3, your lordship
Yes.
may see. As NN Global Mercantile Private Limited could not furnish an earnest money deposit, only the appellant and the second respondent remained in the fray. On 4/7/2024, the Tender Evaluation Committee, while referring to Clause 5D of the NIT, rejected the applicant's technical build, holding as follows. As per clause number 5D, past experience criteria of NIT bidder is allowed to use the past experience of their previous consortium or JV proportionate to its share in that consortium if defined in the consortium agreement. Otherwise, lead partner, if not defined in the consortium, to meet out the past experience criteria of the tender. The firm has used the credentials of their consortium, Messrs. Hind Maha Minerals LLP, for meeting out the past experience criteria. However, agreement of the consortium or JV is not submitted.
Since the shareholding pattern has not been defined, so
Malus.
the lead or the JV itself
Malus.
cannot be considered. Anyhow,
it was, my lord, so far as the Supreme Court is concerned, my lord.
That was the NIT was when their bid was rejected.
Their bid was rejected.
5D of the
my lords. Then it matter traveled up to the Honorable Supreme Court. The Honorable Supreme Court, my lords, held, my lord, if your lordship would kindly see, that it has, if you need a document, you have to spell it out, my lords. That I request for SRD. Then your lordship may kindly turn, my lords, what is the disqualification? Reason for disqualification, paragraph 14 at page 9. First, your lordship, first let us consider whether the decision of the High Court to uphold the appellant's disqualification under Clause 5D for not furnishing the JV agreement is justified or not. Clause 5D of the NIT requires the bidders to furnish documents relating to past experience in similar work. The clause further provided that the bidder is allowed to use past experience of their previous consortium or JV proportionate to its share in that consortium if defined in the consortium agreement. Otherwise, lead partner, if not defined in the consortium, to meet out the past experience criteria of the tender. Subclause 1 and 2 of the said clause stated the following documents are to be submitted.
So the majority shareholder or this has an experience and they submitted their document.
And the JV, my lord, unfortunately was not submitted.
Says that what is the proportionate share of the, that was the only thing that they
True.
could not
No,
identify.
my lord,
what is a share?
the share, and they said
Matter was not given.
no. So the reason for cancellation, my lord, was that the JV agreement was not given. Because as your lordship would kindly, my lord, come back, my lord, to page paragraph 4 at page 3, my lords.
That I find
My
is
lords.
mandatory.
Then your lordship may kindly come to my lords para 18, my lords, at page 11. Your lordship got it, my lords? Though the submission of a JV agreement has not been expressly stated in the aforesaid clause, the
It does not invite the or mandating the submission of the JV agreement itself.
Malus, because it was not mentioned that the JV agreement should accompany the tender.
Then
Then
subparagraph 3
subparagraph
says that it should be very clear and unambiguous.
19.3, my lords.
Yes, I have seen
19.2 and 19.3, my lords.
19.2,
Having they
there
cannot
is no
trust.
doubt. 19.2 says there was no doubt.
No doubt.
About
3, my lord, culls out, my lord, the reason for which they have interfered, my lord.
They say that if you have not identified, you did not demand as a mandatory
My lord.
conditions, then you can't.
Can't. And ultimately, my lord, they, at paragraph 20, my lords, in these circumstances, we are inclined to hold paragraph 20 at page 16, my lords, to hold that first respondent
unfairly rejected for non-production of the JV.
My lords. Thereafter, my lords, this was followed in another judgment, my lord, of my lord's Honorable Supreme Court on the 31st of October 2025. I'll just take your lordship to the relevant portion. This particular judgment was followed. My lord, that is at paragraph 13.
Same bench.
Same bench.
So,
same bench. They followed it, my lords, and they have referred to
What do you expect?
Sorry, my lords.
No, what do you expect? Not to follow?
No, my lords. Now the Honorable Supreme Court has said, my lord, the
Same bench.
other coordinate benches should follow the High Court coordinate benches.
It's the same bench.
Same bench.
Composition is one and the same.
One and the same. So in different dates, the Honorable Supreme Court, why I'm trying to point this out to us, that they have, my lord, said consistently that if you want a document, please specify. If you want a supporting document, please specify. You can't turn around and say that this is a supporting document which should have accompanied the tender. And the clauses being and so far as the and so far as, my lord, the successful tender, the L1 is concerned, he has more or less repeated, my lords, the same issue, my lords, of my alternate redressal mechanism being available, and also the supporting documents. So I need not place the counter, my lord, and the rejoinder which I have said, because the East Coast Railways, my lord, and the East Coast Railways, they, my lord,
railways are.
and once the railways, they say, my lord, I do not have to place the counter of the other successful petition. So in a nutshell, my lords, my humble contention, my lord, is
Hearing
my lords,
the mandatory or not mandatory.
my lords.
My lord, I'm also taking the same page 33. You should read conjointly that clause 2.1.3. Then
2.1.3.
Yes, it's the same.
Yes, then I am coming to the 2.1.1 and I refer to. The bid shall be furnished in the format exactly as per the appendix 1A and 1B. That is the technical bid.
Where from you're reading?
I'm reading the 2.1.4.
Read petition.
Read petition, page 33.
2.1.4.
Yes, ma'am.
Yes.
The bid shall be furnished in the format exactly as per the appendix 1A and 1B. That is technical bid as per the appendix 1A and financial bid as per the appendix 1B. And it shall be signed by the bidders authorized signatory. The bidder bid price such and such. Then Lordship is coming to the next 2.1.5. The bidder shall be submitted a power of attorney as per the format at appendix 2 authorizing the signatory of the bid of the
To commit the
bid
bidder.
to commit the bidder. So this 2.1 and 2.1.4 and 2.1.5 should take conjointly. This very word before the technical bid, the bidder shall furnish the format exactly as per the appendix A by 1 and B.
Mr. Deputy Solicitor General, the thing is that you have not rejected that this is not in terms of appendix 1A or B. What you have said is that you have given an appendix 2, no doubt it is there, but you have not submitted a supporting document. That's the only ground on which you have rejected. So, question of appendix 1A or 1B's adherence is not there, is not an issue. The issue is there must be a submission of a supporting document. Now, question is that appendix 2 ordains a supporting document or it does not ordain. You have not said appendix 2 is not done in a format. It is done in the format, but not with the supporting document. That is a board resolution.
My lord,
Does it require a mandatory conditions? That's the only question.
yes. Then lordship may come to page 47. Again, the page 47.
Please.
Yes. The first 2.11.1, they already read it, so I am coming to my supporting clauses. Next paragraph. The bidder shall then apply for the RFP on the website such and such by submitting the documents mentioned below along with the supporting documents which shall be comprised the technical bid on the e-portal. That means the document is not a case that we are disputing that he has not submitted the part document physically. We are admittedly he has submitted the document physically, trying to, but it is a case even though he might have prepared the document, he do something in the technical in the time of submitting the e-filing, he didn't submitted the document with authorized signature according to page 33, 2.1.
From where you got it?
Yes,
That's the whole thing. Please.
Yes.
Please consider, he wanted to create a distinction in
Yes.
that clause. He is also relying on that the
Yes.
bidder has to
Yes.
submit or apply the RFP online and by submitting the documents mentioned below, means A to H. Let us segregate it. By submitting the documents mentioned below.
Yes.
You got it?
Yes.
Let us stop here.
Yes.
That means you wanted this A to H to be there, whichever is applicable.
Exactly.
Correct?
Yes.
Then read.
Then B.
Along with.
Yes.
Now, question is, he has submitted those documents A to H. Then he says, along with the supporting document, which shall comprise of the technical bid. So he says that along with the supporting document has to be mentioned in those clauses where he says that so far as clause A is concerned, you have indicated supporting document.
Yes, the B is very clarifying.
Coming. His contention is,
sorry, sir.
So far as A is concerned, you have used the term Appendix 1A with annexure 1 to 7 and supporting certificates and documents. So annexure 1A, he says I have complied or whatever is applicable to me. Then B says power of attorney for signature as per the format. He says that it does not contain a further expression, any supporting affidavits or document. It is only the power of attorney exactly in the format given in Appendix 2. I have given a document in Appendix 2. He has said so. Supporting document when you want. Then he says that there should be a clarity in this regard. I had those documents. Then he said note was appended to Appendix 2. The reason being that everybody should not give. It says that I'm giving you, if you have any doubt, you can call for that supporting document or for verification of the document that is there in the note appended to Appendix 2. So you have not called for.
Wherever Required.
Wherever required, that is what means you have a authority to call for. No difficulty. You would have called for. Then you are saying a power attorney executed by him. No problem. Where is the supporting document of board resolution? Where is the supporting document of authorization? No problem. You would have produced it. That is why this judgment of the Supreme Court is cited, saying that it must be very clear and unambiguous. Everything has to be spelled out. If there is a confusion which is created,
Well, that's why it is
then in that
clarified
event, what?
2.11.2. That's why the scope is crystallized.
Show us.
This the bidder shall submit the following documents physically
Huh?
within the time as mentioned in the clause
did you
1.3. That means
Come A.
yes,
Come to A.
the original power attorney of the signing the bid as per the format of Appendix 2.
That
Yes.
is what it says.
Yes.
Appendix 2 does not talk about the supporting documents. It simply notes says that as and when required, if you ask for any document in support thereof, then he will produce. He has to produce.
I mean, according to him, this is the argument, but it is the
But
bidder
that is
document
the apparent,
instruction of the bidders. Let's see once again in section 2 bidder test 33.
please.
That the 2.1, 2.1.4 and 2.1.5. That 2.1.5 is specifically said so the bidder should submit a power attorney.
That is what is
Yes,
saying.
that's why that should means they will submit the document.
No, because it is qualified by another word after power of attorney. Read. Please read that sentence. Bidder shall submit the power attorney.
Yes, as per the format.
What is the meaning of this?
That format is given by the department.
If the format does not say that the supporting document has to be annexed, then a note says, as and when required, you can ask for the support.
And it is not your case that it is not in the form.
And your case is not that this appendix 2 is not in the format. You have not made out the case.
This page 81 is
please come where it requires supporting document. Please come to page 82 notes.
I'm coming to the
Yes,
81
page 81 you read.
Yes.
Let us see. These are the very usual words. Such and such bid. I have been authorized.
Wherever required. Next paragraph.
If you look at 81, it does not really talk about any document to be annexed.
But the page 81.
81 does not require any document to be annexed.
It
says I known by these presents.
This appendix 2 is started from the format for it is a format for power of attorney for the signing of the bid.
True.
That is refers to clause 2.1.5.
True.
Yes.
That is what it says. Yes. So this is the format. Power of attorney must be in this format. They cannot add, they cannot subtract any word from this format. Please consider.
Yes.
But what it says, known by these presents, we, then the name of the principal has to be incorporated. Do hereby irrevocably constitute, nominate, and appoint and authorize Mr. such and such, means the agent, such and such residing who is presently employed as a lead member. This is not required because they are not joint venture and holding the position such and such to act, to do such act, deed or things as are necessary or required in connection with the incidental to this bid for the project proposed to be developed. So this is what the authorization comes. And who can sign? In the witness, signature of the person authorized by the board of resolution in case of a former company, partner in case of a partnership firm, then it has to be done by a notarized one. That is also they did. They are not supposed to support a document. They have executed it, duly notarized. You have not rejected on that ground. Then come to the notes, page 82. The note says, first mode of execution of the power attorney shall be in accordance with the procedure that is under the Power of Attorneys Act. It has to be done.
Yes.
No problem. Yes. Two, he is saying, wherever, whenever or wherever required, the bidder should submit for verification. the extract of the charter document and the documents such as the board or shareholders resolution, power of attorney in favor of the person executing this power of attorney for delegation of the power means wherever required.
They have repeated that it's just on the
Well, that's why
Wherever, what is the meaning of the word? Is it mandatory? It is obligatory on your part to ask for those documents. And it specifies the board resolution, it specifies the power of attorney.
then let's may come to the page clause 2.90, page 50,
Page
90, page 50,
50.
50,
Yes.
2.19.
Please.
Correspondence with the bidder.
Yes.
2.19.
Yes.
19.
Yes.
Save and accept the provided with the in this RFP. The authority shall not entertain any correspondence with any bidder in relation to the acceptance or rejection of any bid.
So that is the correspondence. If they make a representation, why? Give me a reason. Please give me a reason why you have rejected it. What was your understanding? These correspondences, you say, I will not entertain any correspondences. Foreclosing the door for a further approach to you.
But
What does it mean?
this is the case where he could not submit the proper document for which he was rejected the technical bid. He is not come to the stage of financial bid.
You are absolutely correct. That if he does not submit the proper document or a requisite document, there is no fault on your part in rejecting it. But the question lies, what is proper document and what is a requisite document?
That is in clause 2.14 and 2.15.
Appendix 2 is the proper document and the requisite document. Only Appendix 2. It does not talk about any supporting document with the Appendix 2.
But in page 33, it is specifically noted in 2.1.5, the Appendix 2. That means
Appendix 2 as a whole. And Appendix 2, 81 does not talk about any annexation of the document.
Yes, but
note says if we require, means you require, they will submit. But you are not required.
My lord, I am appearing. My lord, I am appearing for
successful bidder, sir.
Yes.
Sir, you are appearing for a successful bidder.
Yes. Yes.
OP number 4. Yes.
Yes. Sir, you have no role to play. I believe this is there. No.
Yes. Have you supplied the copy?
Page 150 to 156 says that the contents of the petitioner's own submission in its Annex 3, copy of the board resolution passed in board of the directors meeting dated 29/5/2024.
From where is reading? From where? This is.
I'm reading from page 150 to 156.
150
of the petition.
Yes, sir. Yes, sir.
This is general power of attorney.
It's a general power of attorney.
Yes, sir. Yes, sir.
Come to page 1.
Annex 3.
And it's 150.
Yes, sir. We are at 150, sir.
151.
Yes.
Para 9. To appoint attorney, both general and special, from time to time, as and when necessary, to provide for the management of the affairs of the corporation in India and abroad, particular to the appointment of any person to be the attorney or agent of the corporation with such power and upon such terms as may be thought fit. 31. 31.
Yes.
155.
Yes, sir.
Lastly, 31, 31. Lastly, the corporation hereby expressly declares that this power of attorney and the power of authority hereby given shall remain in full force and effect until notice of the revocation of these presents shall be received by the attorney. The board of directors unanimously gives authority to the chairman to decide the matters, but out of the above matters, and that could be delegated to the managing director, and the chairman will convey the decision at the earliest to the managing director, and the same would be placed for information of the directors in the forthcoming board meeting. Further, the board of directors authorize managing director to subdelegate and the powers entrusted to him to any officer or officers of the company as per the articles 68(2) of the association articles of association. It is this 2.1. Amounts violating clauses 3.1.6.11 specifically clause 2.1.77, which states any condition or qualification or any other stipulation contained in the bid shall render the bid liable rejection as non-responsive bid. Page 33. This is in page 33. Para 2.1.7, any condition or qualification or any other stipulation contained in the bid shall render the bid liable to be rejection as non-responsive bid.
Sir, you are absolutely correct. The power is conferred or reserved upon the railway authorities to reject the bid or to treat it as non-responsive. They have the power. The question is when and in what manner this power is to be exercised. There must be some kind of a conditions or a violation of the conditions which will invite invocation of 2.1.7. So that is what is the main issue, and the power of attorney is already given.
Page 82. Page 82.
Yes, sir. That is a notes appended to Appendix 2.
Wherever required, the bidder should submit for verification the extract of the character
Charter
documents such as board shareholder resolution, power of attorney in favor of the person executing this power of attorney of the delegation of power here and on behalf of the bidder.
So the question is, what is the real issue is, the real issue is, what is the real issue here, that if those documents are not required to be annexed or to be submitted at the time of submitting the power of attorney as per an appendix 2, then in that event, can the authority reject the bid that you have not submitted the document? When this note says that if the authority thinks or require the submission of those documents, he can ask the bidder to submit those documents. That stage never arrived.
Wherever required.
Wherever required means it is a discretion or a discretionary decision of the authority that I require this document to be submitted. Then a notice has to be given to him to you give me. You have given me a power attorney as per an appendix 2. Now show me the document in support thereof. They could have produced the document. No difficult. So it's an option. It's an option which is given.
And read it once more. Wherever required, the bidder should submit for verification the extract of the.
What is the meaning of the word verification, sir? That means they will ask the production of those documents in physical form and they will verify whether it is in tune with what you have said in the first portion of appendix 2.
I don't think it would be correct.
Huh? Then sir, what meaning can be assigned to it, sir? Wherever required, then what meaning can be
wherever required, the bidder should submit.
Yes, for verification.
Verification. The extra.
So it's qualified. It's a qualification. What purposes? For what purposes it has to submit?
Verification of the extract of the charter and charter document and the documents such as the board of shareholder, the resolution power of attorney in favor of the person executing this power of attorney or the delegation of our hereunder on behalf of the bidder.
The timing is important because you submitted when the power of attorney is submitted. The timing is important.
Here in this case, the timing is important because when you submit, the bidder when he submits, then it comes. You know, to find it comes that attorney delegation of power hereunder on
behalf of the bidder.
Behalf of the bidder.
When he is obtaining the bid, not after.
May I clarify some points after this?
Sir, what you say is definitely if certain documents which are required to be submitted must exist prior to the last date of submission of the bid, no bidder will be permitted to submit or to furnish the document after the last date of the submission. There is no quarrel, sir. This is a very fundamental principles in the tender process. But the question is that whether those are the required documents as per appendix 2, because I find there is no stipulation that it has to be submitted. And that is why the petitioner has relied upon a recent judgment of the Supreme Court, which says that if the language in the tender document is somewhat obscure or there is some ambiguity, then in that event you cannot reject the bid. It must be very clear, unambiguous. We find there is a different way of interpreting it.
Page 81, appendix 2.
Yes. It's the format of the power attorney, sir.
This is
simple.
read together. Format of the power of attorney for signing the bid.
True.
Refer clause to 2.1.5.
Sir, this is really an the principal and agent agreement, as we know under section 182, 183 of the Contract Act. So this is really the person who is submitting the bid is like an agent of the principal.
To 2.11. It's here. Page 47. Documents comprising technical and financial bid. 2.11.1. The bid shall first upload all the project details, including technical capacity, financial capacity, net worth details, turnover detail, and all other detail required in the RFP for technical qualification. The bidder shall ensure that all the details are updated as on the due date of submission of the bid. The bidder shall then apply for the RFP of the website https government in by submitting the documents mentioned below along with supporting documents, which is an umbrella provision. And then shall comprise the technical bid on the EE portal. Appendix IA. Yes. Appendix IA, including Annexure 1 to 7 and supporting certificates, documents. Then B, power of attorney for signing the bid as per the format at Appendix 2. Format and has to present.
Sir, it is already lunch, so we should.
No, complete.
Please.
There is no difficulty because
We should complete
the
it.
question is very simple, as we find. I think as a successful bidder, he has a very, very, very small role to play, because these are the action of the tendering tender issuing authority and the intending bidder. He has been adjudged by the tender inviting authorities, so he has to wait for the consequences to follow. Nothing more than that.
Our limited our submission could be is just to clarifying the court's mind, my lord.
And the
Let's get
Supreme
two-
Court has said that we are declaring him as the highest bidder. That does not tantamount to
I am not that
accrued
point.
or
I am that
input
point.
right of a contract.
No, I am not that point. We are submitting here that, my lord, here
We have to define, we have to consider
yes,
whether this submission of the document means the power of attorney, I mean, by the company, and the board resolution are sine qua non to Appendix 2. And if it is sine qua non, there is no quarrel, no ambiguity in our mind that if they have not submitted, which is an admitted position, then it must fail. If we find that it is not mandatory, it is not imperative on them to submit those documents, as it is optional and at the option of the tendering inviting committee, then in that event, whether the rejection at the technical bid can be justified. This is the only question on the basis of those clauses which have to interpret. We have to interpret nothing more than that.
Well, this may might have clarify in the clause 3.1.65 land senior separate. Then I am coming to 3.1.6.1.
Yes.
Then page 53.
Yes.
Yes. that as per the first step towards the evaluation of the technical bids, the authorities shall determine whether each technical bid is responsive to the requirements of this
True.
RFP.
Who
Technical bid
denies?
shall be considered.
I think they are also not denying.
That let's make up the clause D. The clause D, the power of attorney is uploaded on e-procurement portal as specified in the clause 2.1.5.
True.
That means
That is what he is also admitting.
yes,
Has to be uploaded.
yes.
And it is a case that I have uploaded. Please kindly
No,
consider.
he has not uploaded.
He has uploaded the power to
Annex
the appendix 2. What are you
Annex-
talking? You are
Appendix 2.
saying rejecting, giving a clause. Have you seen that clause? Rejection clause. What are you talking?
157.
Please.
57, yes.
Yes. Please look at this.
Extract of just a minute. Extract of board resolution not attached.
True. What? Rejection.
That means that's why
Extract,
why
it is only the extract of board resolution. It
Why?
is not that an appendix 2. Otherwise, you would have said appendix 2 is not there.
Why you have said so? Because their own document in respect to the power attorney, let's say when counter we have filed the annexure A by 1. This let's say come to the page 31. Our continuing page, sorry, my lord, this counter. Page 31. Delegation of power. Unless until we don't know who is the delegated authority to whom they have delegated the power.
That is
I,
appendix 2.
is why,
That's-
sir,
Yes.
this is why the note 2 was appended.
Yes.
That if any confusion has a reason in your mind that whether the delegation is proper, he is a delegate, then you can ask them to produce. Give them a document. Why?
These two things are happening in the tender process.
No.
One in e-filing and
say.
second is physical. Whenever means on the subsequent, whenever required to be a physical presence and document, it should be submitted.
True.
It is but not that prior to that you will not submit the document, subsequently submitted
Let
some
us see-
document, it will
let
take
us
care
see
of.
whether it is
And that was
there.
exactly what the Supreme Court was dealing with, Milords.
Oh,
Because they had ambiguity regard. But I'll not repeat that, Milords. They had.
And we don't have any problem to go with anybody.
No.
But we want to work.
We could have dictated the judgment here and now. So we have the another bench from 2, so that is a whole difficult.
And my price bid is
Just keeping
42
matter.
crores less.
Judgment point. Give the judgment point.
Milord, I have given them. But
Monday, give.
Milord, I have
Yes, sir.
given
We will take note of your submission, sir. Don't worry. From your notes.
My lord is fixing for hearing Monday or judgment? Yes.
and Milord,
Open court.
My
Pay-
bid is 42
Don't
crores
worry.
less. 42
Pay-
crores, not the government of India undertaking.
We have lost.
We don't have any one year option.
So my
Anybody can
learned,
come, but
my
what should be
learned,
done
my
immediately?
learned friend should be in my favor, Milords.
Sure.
What is the review, sir?
My lord. This
What is
matter,
the wrong in the order?
my lord. This matter, my lord, relates to recruitment of a junior assistant in the registration wing of Jagatsinghpur district because of a wrong valuation of answer scripts prepared by the Board of Revenue. The appointment of respondent number 4 and others were cancelled, and the review petitioner filed the original application before the tribunal that was subsequently transferred before this honorable court.
Where is the order of the division bench which you sought to review?
Well, division bench order, my lord.
May I raise a question of maintainability?
Review maintainability. Why
Yes.
not?
There are 7 writ appeals were disposed of by a common judgment. And the 7, now the person, those who have implemented as a respondent before the appellant before the appellate division bench, they have not been made parties. One person has been made parties in the and the judge appellates.
In the writ petition and single.
Not tenable.
Brother,
Because the review is in relation to a particular writ petition which has been filed.
but the judgment,
Maybe judgment is a common. It's
Common
a
judgment.
common judgment. That does not mean that every writ petitioner or every party in the writ petition becomes impliedly a party in the
But
proceedings.
the
No.
nature of the order is such.
No,
I
no,
ju-
no, no.
that is what I'm trying.
No.
Let him argue then, sir.
My lord, judgment of the Honorable Division Bench is at page 106. Relevant page, your lordship kindly see paragraph 28, 27, 28, 150, 151, your lordship kindly see para 28, my lord.
Yes, sir.
May I read, my lordship?
Yes, sir.
151 para 28. We
Yes,
direct the revised merit list as prepared in the selection committee meeting held on 16/11/22 and 12/12/22 be opened by the collector and district magistrate Jagatsinghpur against 10 vacancies following the reservation rules.
Yes.
Those whose name are in the revised merit list shall be appointed in accordance to the merit position vis-a-vis vacancies if the name of the appellant except the appellant WN number 1437/22. I am the appellant in WN number 1437 of 22 finds clear in the revised merit list. His or seniority will determine in terms of the direction given the learned single judge. But it is found that appellant except the appellant in WN number 1437/22 are not within the merit list. We direct the state to allow them to continue in the post of junior clerk by saving their appointments in the post of junior clerk in the promotion post by creating superannuated post or against the vacancy at present available. Those appellant will be at the bottom of the senior list vis-a-vis persons appointed on the basis of a revised merit list. Whether the appellants whose name are not found in the revised merit list will be given further promotion or not will be decided by the appropriate authority, or otherwise they will retire from the post of junior clerk. Those who are already promoted, their promotion shall be protected.
Yes.
My humble submission in that, your lordship, in the connected writ appeals, my lord, interim order was passed in annexure 8, my lord. Your lordship, 103, page 103, kindly see. During pendency of all the writ appeal, during pendency of the writ appeal, my lord.
I am just asking. 103.
103, page annexure 8, my lord.
Yes. 1 minute. Let me reach to 103, sir.
Fine.
This is in relation to WA 1255.
All are connected writ appeals, my lord.
Whatever.
In one case, order has been passed.
This WA 1255 is also included. Yes, it is included.
Included, my lord. Yes. On the basis of order, my lord, your lordship kindly see the order. I am reading, my lord. In compliance with the previous order, the list of candidates who have been shortlisted only on the basis of the revised result sheet dated 29/3/2015 has been produced in the seal cover. It is pointed that the revised select list shall be prepared only after the shortlisted candidate clear the skill test of qualifying nature. You have perused the shortlist prepared by the selection committee, and we found that it has perhaps not been correctly framed. As for example, Mr. Vijay Parida belonging to SCPC category is stated to have secured 256 marks in the written examination, has not been placed in the shortlist of candidates of SCPC category. Apart being placed in the general category UR on account of his marks secured in the SCPC category, the shortlisted candidates have secured much lesser marks than Vijay Parida. Therefore, we request the selection committee to re-examine the issue. And
so what is the difficulty? So that was
on the basis of that list.
Maybe they may have done, but they have kept it in a seal cover.
And
seal cover will be considered at the time of
my lord, that is my point. So, on the basis of this order, the petitioner name finds place in the review petition name in the revised list, and 105 next annexure, your lordship kindly see. Petition was called to skill test.
Maybe if ultimately the court has found that your name is not there.
In the 105, my name was there.
Where is the finding so far as 1437 of 2022 is concerned?
My lord.
Where is the finding?
Oh, lordship kindly say 100.
Why the court has said that you should not be given?
Your EP lordship kindly say 105 page.
Sir, I have seen, sir. I will ask you a legal question.
Mm,
Don't
my
worry.
lord,
Be ready for that.
My lord,
Let me first ascertain the facts.
my lord,
They clear.
my lord.
The court has said except the appellant in WA 1437. There must be a finding previous to it that why the court has excluded you.
Because my lord,
Page 1. Yes. Why do you exclude this?
Paragraph 9. Exactly. His contention, paragraph 19, page 134.
in para 27 that has been mentioned. Para 27 that has
Just
been
1 minute.
Submission we have had.
That is no. It seems that by virtue of the selection means except the appellate who has come, everybody was appointed.
The appellant in WA 1437 of 2000, page 44, there is a. Appellants. 100. Paragraph 27, there's a finding that you have not qualified in the.
that is qualifying in his nature, my lord. But
In the
subsequently,
computer practical skill test.
Para 19, page 134. The
19
finding of the para 19, page 134.
Para 19 is the submission. I did not find.
But it was also recorded as to why Srivas again is not considered. On the next page, 135. You don't qualify in the computer based test.
even after the revised merit list,
Wait.
sorry,
Oh, that you could not qualify in the computer practical skill test.
my lord. Your
And
lordship,
that was single bench also has found that, and the court has also found
honorable,
that you have not qualified.
honorable Singlejo directed to revise the merit list.
That is true.
The-
Your contention
and
was
this
that
honorable,
the entire selection process is vitiated.
my lord,
Then in that event, it reopens everything,
and
and therefore you cannot be spared. You cannot be spared. That
Ma-
was your contention, is it?
My contention, my lord.
Yeah, sir, I will coming into the scope of the review, sir.
My lord,
I
your
will
lords.
be ready for that. Let me first understand the fact.
Yes.
So there is a positive finding of the court that since you could not qualify in the computer test, skill test, you were not given an appointment, so you become outside the zone thereof. Now, when the court ultimately says that the merit list is to be revisited and or to be uh, the exercise has to be done, then there is a positive finding against you that you are outside the merit list because you have not completed. Now, if this is a finding, now tell me that where is a error apparent on the face of the record which invites the review jurisdiction to be invoked?
My lord, your lordship, kindly see page 105, my lord.
105 is an interim order.
No, 105 after interim order, 105.
I am asking, sir,
My lord.
105 is the interim order.
105, my lord, not interim order.
That was in relation to WA, the 1255.
105, my lord, is the order of the in pursuance to
referred this 105 order.
No.
Oh, this is another.
My lord.
Yes.
In pursuance to Annex 803 order,
yes.
I have found in the revised merit list and called to the computer test. Your lordship kindly see and subsequently qualified. That was not
where
page 105, my lord.
That means earlier you had not participated in the computer test.
But
thereafter you went. But this court has held that no, the
my lord,
computer test is not being challenged.
Your
only
lordship
the written test was challenged.
My lord, your lordship is right.
The difficulty is that maybe by an order of this you were called upon.
My lord.
But ultimately the court did not accept that particular.
That was not sealed cover was not opened. My lord, that sealed cover was
the
not.
Court has proceeded on the basis. No, this has to be done in this way.
My lord, had the sealed cover.
Now tell me whether an interim order creates an inchoate or absolute right, or it is an interim order which merges with the final order. It loses its effect. Can you take any advantage of this?
My lord, had the seal cover was opened, my lord, matter would have been different.
I am saying the court has not taken into consideration, does not find that particular, because the court have gone into it and say that we will consider at the time of final. Finally, the court did not accept that. That's the decision of the court.
But even after revised merit list, my lord, the candidates those who have not appeared in the skill test, computer test, they were appointed. They were appointed.
That cannot be.
Sister were appointed.
That is again cannot be a scope of review.
But
if they have been appointed dehors, you know where to go. But can you go for a review? Question is exercise of a particular jurisdiction.
Only this point 105 would placed before your lordship.
No, sir, this cannot be. That's no right is created because that was an entry point.
That's why.
If the court has consciously omitted you, saying that you have not, then it's better not to.
Even if those were not qualified in the written test, they were continuing because of the court order.
Sir, that is what I'm saying, that this is a post-judgment scenario. Then it gives you a.
And this honorable court, those who were illegally appointed, with the due respect, my lord, those who were illegally appointed, this honorable court protected their rights.
Understand, sir, that may be an erroneous decision. That can this decision be said to be an error apparent on the face of the record? There is a vast distinction between these two categories of order. One is the erroneous order. One is an order suffered with the vice of an error apparent on the face of the erroneous order. You go higher up, get it corrected. Not the review.
This is the only ground.
You can't do it. That cannot be done.
So there is also another finding that in respect of the opinion of the learned single judge, your conduct is hit by estoppel.
Absolutely. I have seen that.
Yes, sir.
And the court has observed.
There's nothing wrong.
Subsequently, I qualified in the
instant review application.
May I please ask?
Yes, sir. What is this?
Upon this contempt application,
My sister's order is not complied with.
yes, ma'am.
What are you doing?
Now in the process of complying, because in the intervening circumstances, SLP was.
What was the direction?
Direction, my lords. Your lordship, my
You
kind.
filed a SLP?
Yes,
SLB dismissed, my lord.
I'm coming to that.
On clip, sir.
SLP has.
Now review file.
No, Millard. SLP was dismissed in the month of December, Millard. Now we have started the process to comply, sir.